Well, hello, everyone. Welcome. This is the second webinar in the Animal Law and Science series brought to you by the Animal Legal Education Initiative at George Washington University and the Camilla Center for Scholarship-Based Animal Advocacy. Animal law advocates use science to help judges and legislators, policymakers, and others understand the need to protect other animals. And recently, sentience and also consciousness have come to the forefront in these legal strategies. This session is going to consider the legal uses of sentience assertions and ask, what is it? What is sentience? What does it mean? And how can it be used to protect other animals? I'm Lori Marino, and I will be moderating this session. We will hear from three great panelists, Mike Radford, who's a reader in animal welfare law and the United Kingdom public law at the University of Aberdeen. Elizabeth Stein, who's litigation director for the Non-Human Rights Project, and Marty McKendry, who's a senior parliamentary advisor for Senators Pierre Delphine and Marty Klein in Canada. They're going to share their efforts to use sentience within legal frameworks and consider how best to use it in the future. They will each give 15-minute presentations, and then there will be a 15-minute Q&A session. So if you have questions, please write them into the Q&A box, and we'll try to get to as many as we possibly can. We're also recording this session, and we'll be posting it on the GW Law YouTube channel. So without further ado, I'd like to introduce Mike Radford, who's going to be our first speaker. Mike?
Thank you very much, Laurie, and thank you everyone else for joining us and welcome. Can you see my screen? Is it sharing okay?
Yes.
Good, that's half the battle then. So thank you very much. So I've called this presentation Animal Sentience, a Political Response. And that is because unlike many countries, not least the United States, the UK and indeed the European Union relies principally on legislation rather than litigation to define how animals are to be treated. So, and of course, that legislation is achieved through the political process rather than the judicial. So far as sentience over here is concerned, we have to start with European Union law. As you may appreciate, the European Union started as a common market. It was a free trade area, and particularly focusing on agricultural goods. And animals initially were simply considered to be goods just like vegetables or other agricultural products. And the NGOs from a relatively early point started to lobby for animals to be to have more favorable recognition. And so they succeeded in getting a declaration on the protection of animals in 1992, but that was all about welfare. It talked about the welfare requirements of animals rather than sentience. It had no legal force. In 1997, they got a protocol on the protection and welfare of animals in the Treaty of Amsterdam, and that is where the concept of animals as sentient beings is introduced. It was thought that that protocol had legal effect, but in a case involving foot and mouth disease before the European Court of Justice called Yeeps, the court said that it had no legal force, and therefore it was back to the drawing board, and it was eventually succeeded in the Treaty of Lisbon that what is called the position on animal sentience was made part of basic EU law. And that says in formulating and implementing the Union's agriculture, fisheries, transport, internal market, research and technological development and space policies, the Union and member states shall, since animals are sentient beings, pay full regard to the welfare requirements of animals while respecting the legislative or administrative provisions and customs of the member states relating in particular to religious rites, cultural traditions, and regional heritage. You'll note that sentience isn't defined, that according to this, all animals are sentient, and the requirement is to pay full regard to the welfare requirements of animals rather than to give effect to them. So they have to be taken into account, but can be overridden by other considerations. When it came to the UK leaving the European Union, there'd been a undertaking by government that sentience would be included, but there was no mention of it when the appropriate legislation was published. An MP put down an amendment in Parliament to get it included, but that amendment was opposed by the government. They said that animal sentience was already implicitly recognised in UK law as the basis of our animal protection legislation. And the government said that incorporation of sentience would add nothing and be fairly superfluous. That, quite wrongly actually, was reported in one of our national papers as that the government was in denial that animals can feel pleasure and pain, which they weren't. But it was very useful because there was a huge social media response to that. And within a month, the government had changed policy and proposed to expressly recognise sentience. They made a statement saying that the government is committed to raising animal welfare standards and to ensuring animals will not lose any recognitions or protections once we leave the European Union. And a draft bill was published called the Animal Welfare, Sentencing and Recognition of Sentience Bill, and that would have provided that ministers must have regard to the welfare needs of animals as sentient beings in formulating and implementing government policy, and also in discharging that duty, ministers must also have regard to matters affecting the public interest. It was a very badly drafted bill. Welfare wasn't defined, animals wasn't defined, sentience wasn't defined, and matters affecting public interest wasn't defined. And it was pointed out to ministers that it was just a recipe for a succession of embarrassing judicial reviews. So the government withdrew the bill and then had another think about how to deal with this. And the way they've dealt with it is they've set up something called the Animal Sentience Committee under the Animal Welfare Sentience Act 2022. And this is actually quite an interesting constitutional issue in that they wanted to keep this issue out of the courts. They wanted to keep it in the political forum. So the role of the Animal Sentience Committee is to scrutinise the formulation and implementation of government policy, and to ask the question whether or to what extent the government is having or has had all due regard to the ways in which the policy might have an adverse effect on the welfare of animals as sentient beings. If the committee considers that the government has not had all due regard, then it makes a report to Parliament, and it is up to Parliament to hold ministers to account and decide what to do with it. The other thing that the Animal Welfare Sentience Act did was that it extends the recognition of sentience beyond vertebrates. Hitherto, the line in the UK and indeed the EU has always been drawn at vertebrates on the assumption that by definition, vertebrates have a spinal column of some sort and a nervous system which is related to our nervous system, and therefore it's assumed that they have the capacity to feel pain. But the Sentience Act formally recognizes that cephalopod mollusks, that's squid and octopus, and decapod crustaceans, that's lobsters and crabs, are sentient. That's based on scientific evidence, and there is an enabling power in the Act to extend the definition of sentient animals to include invertebrates of any description. If it is extended, it will be on the basis of scientific evidence. I don't want to get into the mechanics of devolution, but that act applies to UK government legislation passed for relating to England, and also legislation passed relating to the UK as a whole. But so far as animal policy is concerned, and animal protection and animal welfare, most areas of policy have been devolved to Scotland. And Scotland has come up with a rather different way of dealing with this. It's passed legislation, the Scottish Parliament has passed legislation establishing the Scottish Animal Welfare Commission, and that's been established since 2020. And the role of the Commission is to advise the Scottish Government on any matters concerning the welfare of domesticated, kept, or wild animals. And the Commission, the definition of sentience isn't in the legislation, but the Commission has come up with its own definition, which it applies. So it defines animal sentience as the ability to have physical and emotional experiences which matter to the animal and which can be positive and negative. And it therefore says animal welfare is relevant to animals that have this ability, and the Commission defines animal welfare as the mental and physical state of an individual as it experiences and engages with its environment. Now, as I've said, we don't have a lot of litigation relating to animals in the UK. It's mostly done by legislation. But the concept of sentience, the issue of sentience, is relevant whether you're in a system which relies on legislation or a system which relies on litigation. The UK government has accepted these two groups of invertebrates are sentient on the basis of scientific evidence. Unlike law, science is not jurisdictional. It's universal, or certainly in terms of planet Earth. So if the scientific evidence points to vertebrates, and at least some invertebrates being sentient in the UK, this evidence is equally applicable in the US or anywhere else. And there I'll finish.
Thank you so much, Mike. That was really interesting. I'm sure there are going to be a lot of questions. And I just want to let the participants know, the attendees, if you have questions, please put them in the Q&A, and we'll try to get to them as many as we can. So our next speaker is Elizabeth Stein with the Non-Human Rights Project.
Okay. Thank you, Lori.
There you go.
Am I good to go?
Yes.
Okay, let's see. Here we go. Thank you so much for having me. This is truly an esteemed panel. Mike, that was fascinating. And before I even get started, I think what's going to be really interesting, and I hope we can get some questions about this later. I know that we're talking about sentience, but what we at the Non-Human Rights Project talk about is autonomy. And that's what my presentation is going to focus on. And I think it'll be interesting perhaps later if we can delve into a little bit why we discuss autonomy as opposed to the concept of sentience. So just to begin, what is the Non-Human Rights Project? We're an organization that was founded in 1996 by attorney and animal rights scholar Steve Wise, and we're the only organization in the United States dedicated solely to securing legal rights for non-human animals. We believe that the only way to truly protect the fundamental interests of non-human animals is through the recognition of their rights. And we work to secure these rights through litigation, legislation, and education. Through our work, we are attempting to break a hole in that impenetrable wall that separates animals as rightless things from humans as right holders. We argue that science demonstrates that autonomous animals need and want to live freely and suffer when they cannot. We also argue that it's arbitrary, irrational, and unjust to deny a right to a non-human animal based solely on species membership. Let's see how we get my next slide here. Here we go. Our litigation. So we began our litigation campaign in 2013 when we filed common law habeas corpus petitions on behalf of imprisoned chimpanzees in the state of New York. Since then, we've filed on behalf of chimpanzees and elephants in New York, Connecticut, California, Colorado, Michigan, and Hawaii. In our petitions, we argue that based on the proven scientific record, the court should recognize our clients' right to bodily liberty, find their detention unjust, and release them to an appropriate sanctuary. And just to kind of talk about our work for 2 seconds, some watershed moments in our fight for non-human animal rights include securing the first habeas corpus hearing on behalf of a non-human animal in the United States, and that was on behalf of the chimpanzees Hercules and Leo, excuse me. And the first habeas corpus hearing on behalf of an elephant, that was Happy. And then the first time that the highest court of an English-speaking jurisdiction heard a habeas corpus case on behalf of a non-human animal, and that was Happy's case that was heard by the New York Court of Appeals. And we'll be talking about that decision a little bit later, but while the court did not rule in favor of Happy's freedom, 2 of the 7 judges wrote exceedingly powerful and lengthy dissents supporting Happy's right to liberty. And just as a little side note, you'll see the photograph of a chimpanzee. That is Tommy. Tommy was our first client. He's a chimpanzee who was privately owned and imprisoned in a cage in Gloversville, New York. And I think what is so extraordinarily important about Tommy and this photograph is that former Judge Eugene Fahey of the New York Court of Appeals, which is New York's highest court, when seeing this photograph and taking the science, the decades of primatologists, the affidavits that we supply to the court from these primatologists, he said we can no longer look at animals, non-human animals like Tommy, in the same way. That science is so advanced, and it has to change the way we are thinking. And because of the science, he really paved the way for Happy's case to be heard by the Court of Appeals, because he said we absolutely have to now think about how we treat animals with respect to their rights. So why habeas corpus? Basically, what we're trying to do is get the fundamental right to liberty recognized in a non-human animal and have the court determine that their imprisonment is unjust and have the animal released to a sanctuary. And that is what habeas corpus does. Common law habeas corpus it's the judicial guarantor of liberty and has been used throughout history in situations where it would be unjust to leave the status quo unchallenged. And as we all know, the legal status quo of animals for centuries is that they are rightless things. We argue that habeas corpus safeguards against the unjust violation of an individual's right to bodily liberty. Individuals like elephants, great apes, and cetaceans, who are scientifically proven to be autonomous, should have their right to bodily liberty recognized. Science has proven that these autonomous individuals also suffer in captivity. We argue that the law must catch up to proven advances in science. We also argue that the law must reflect society's values and aspirations. Why autonomy? Autonomy is at the heart of the right to bodily liberty, which is one of the most closely guarded rights an individual can possess. With every habeas corpus petition we file, we submit affidavits from world-renowned scientists and other relevant experts who, on the basis of their own peer-reviewed work, attest to the autonomy of our imprisoned clients. Collectively, these affidavits form the basis for arguing that the animal's autonomy is sufficient, though not necessary, for the recognition of their right to bodily liberty. In other words, these non-human animals possess the capacity that habeas corpus protects. What is autonomy? And that, we talk about, Mike was talking about definitions, and this is something that I also hope we can talk about a little bit later, because this is what a judge wants to know. We in the Non-Human Rights Project, in our papers, in our pleadings, in our briefs, we rely on autonomy. Lori knows I say it all of the time. Our cases rise and fall on the science, and it's the science that has demonstrated that these non-human animals are autonomous. But what does it mean? So what I always say is, it means what the science tells us. It's not what I believe. It's not what a dictionary definition says. It's what our experts say. And in a very short way of describing it, they say it's self-determined behavior that's based on freedom of choice. But what exactly does that mean? You might see your dog who seems to be exhibiting self-directed behavior. He's choosing a bone over a ball. Isn't that self-directed behavior? But is it different when we're talking about cetaceans, elephants, and great apes? And from what the science is telling us, that answer right now appears to be yes. Science might tell us something differently a year, 10 years, 50 years from now. But right now, we know what the science is telling us. And it has all different components of autonomy, which you can read on the slide. But what I thought I would do is kind of apply these components of autonomy to our elephant and chimpanzee clients. And this is what we know with respect to elephants and their autonomy. What they do is they travel 20 hours a day across diverse terrains to locate resources, maintain their body, connect with friends, and search for mates. Females are the matriarch of multi-generational herds. They engage in complex, intentional communication with other elephants. They make decisions, they solve problems, they resolve conflicts, they engage in true teaching, they pass information down from generation to generation. They understand death, they have the capacity to grieve, they're empathetic, they engage in funeral practices. And a recent study suggests that they even call one another by name. Chimpanzees as well, they're highly social. They live in fluid subgroups. They construct hundreds of tools which they use, and a large part of their day is spent foraging for food. They're cooperative, they're deceptive, they're funny, they imitate, they have imagination, they perform mathematics. they too experience empathy, pleasure, grief, depression, and boredom. And when they are able to communicate about past events, and they say what they intend to do in the future, they remember their past, and they plan for their future. And when they know their future is imprisonment, they suffer that enduring pain of isolation. So what we're trying to do is using habeas corpus and our science and the experts, is to bridge science and the law. And that's because every habeas corpus petition we file, as I said, is supported by affidavits from world-renowned scientists attesting to the autonomy of the imprisoned non-human animals. What else does science tell us? It tells us about the autonomy of these extraordinary non-human animals. It also tells us about, because they're autonomous, how they suffer in captivity. And this is what we know, what science has told us about elephants suffering in captivity. They suffer when they're confined in small spaces, and they're deprived of social contact with other members of their species. Their isolation leads to depression, boredom, aggression, failure to thrive, and brain damage, which is often manifest in stereotypical behavior, such as head bobbing, swaying, and trunk swinging. And despite what many people think, elephants are not dancing when they do that. They're actually exhibiting stereotypical behavior, which is generally a sign of brain damage. They also suffer foot disease, arthritis, and obesity. We know that with respect to chimpanzees, the harms of captivity include premature death, heart disease, diabetes, abnormal and self-injurious behavior, brain damage, stereotypical behavior, increased aggression, and abnormal sexual behaviors. And again, because they know their past and they plan for their future, they understand when their future is continued imprisonment. So how have the courts reacted to what we're talking about today? And a lot of the courts are reacting very favorably. We know that Judge Fahey, who's now retired, who I previously mentioned, who is really the judge who I believe paved the road for all of this to happen, looked at the science. And by looking at the science, he was able to determine that there is more to these non-human animals than being treated as mere things. Judge Rowan Wilson, who is now the chief judge of the New York Court of Appeals, he too understood the importance of animal autonomy, and he understood that the advances in science should be really gearing us and steering us to making the correct calls, because that's what the common law does. It follows advances in science. And Judge Jenny Rivera, also of the New York Court of Appeals, also understood that these are animals who are extraordinary and need to be treated differently. One of the great US Supreme Court cases discusses perhaps their rights with respect to human beings. We believe it's still analogous to the rights of non-human animals. And if I could just close by saying most of what I've discussed is with respect to litigation, but an amazing piece of legislation was passed in September of 2023 in Ojai, California. It was inspired by Happy's case, and it's a bodily rights ordinance that protects the bodily liberty of elephants. And what's very, very interesting is that the ordinance discusses autonomy both in its preamble and in its definition of bodily liberty. So thank you all very much.
Thank you so much. I really appreciate it. So many interesting points that you bring up in relation to what you're doing and what Mike said. Let's go to our last, but not least, presentation, which is by Marty McKendry. And then we'll take some questions, have some interesting discussion. Marty?
Thank you, Lori. I'll share my slideshow here. Okay, did that work?
Oh,
No, not yet.
not
Oh.
yet.
Did you do the share screen button first?
Oh, hold on.
There you go.
There you go.
Great.
Great.
Perfect.
Great. So thank you very much. We're talking about uses of sentience in legal advocacy. And I'll tell you about how this concept connects to Canadian animal protection legislation at the federal level. Today, I'll talk about 4 bills. So 2 of these bills have now become law, one being a whale and dolphin captivity ban, and the second being a transition out of chemical testing on animals. The other 2 bills are now before the Senate, which is rather exciting. And one of those is on legal protection for captive elephants and great apes. And the other is a proposed ban on exporting horses for slaughter overseas by air. I've been fortunate to work closely on all 4 of these bills, and whether implicit or outright, sentience has been an important concept in all of them, and sometimes explicitly arisen in debate. And I emphasized, as other panelists have, the importance of making a solid scientific case to draw ethical conclusions. So first, whale and dolphin captivity laws. In 2019, Canada legislated a phase out of whale, dolphin, and porpoise captivity. Important to mention that porpoises sometimes get overlooked. And Canada also banned performances for entertainment purposes. Vital to the success of this initiative was scientific evidence of the biological characteristics and needs of these species, as well as evidence of harms in captivity. Parliament considered, in sort of the political aspects of this, the human-like features of these species, so such as self-awareness, as proven by Lori, with us today, of course, and as well intelligence, emotions, social relationships. Parliament also gave a lot of weight to the range size, that whales and dolphins would have, particularly as compared to swimming pools, and as well gave weight to evidence of harms such as stereotypies, being abnormal repetitive behavior, physical ailments, lifespan, and infant mortality. All this evidence connects to sentience in terms of beings that have feelings, sensations, or experiences. I would note, though, that there's probably sort of in the political and public debate some confusion about the meaning of sentience in terms of whether that refers to self-awareness or more general feelings. And I would just say in legislative advocacy, the senators and staff supporting them always try to use plain language. And on a bill like this, I would say people are persuaded by evidence that really shows the similarity between these species and humans. It's sort of, well, if you acknowledge there should be obviously legal protection for humans and these creatures are so similar, you can't say there shouldn't be. And that people are also persuaded by obvious cruelty. And I think in the case of whales, it's come to that. So in legislation, regardless of the animals at issue, it's vital to make the case, as I said, using scientific evidence. This evidence cannot be dismissed, nor, as we have seen thus far, refuted. In terms of the political dynamics, opponents generally try, I would say, to construe the proponents of the legislation as activists, and would say they have ethical opinions, that it's not objective. However, of course, science is not a matter of opinion, and the science has been very compelling, including on this bill. So with Bill S-203, often called the Free Willy Bill, 20 marine biologists endorsed the legislation, and testimony from 4 scientists was really key, being Dr. Lori Marino, Dr. Naomi Rose, Dr. Hal Whitehead, and Dr. Ingrid Visser. The science supported the bill's legal and ethical conclusions, in this case justifying one of the first new animal cruelty offenses in many years in Canada. It was a major precedent in terms of Canadian statutory law. And I should also note in the debate, along with science, Indigenous values of respect for nature also played a very influential role. Canada is currently undergoing a process of reconciliation with Indigenous nations in our federation, and in particular the First Nations concept of all our relations that Senator Murray Sinclair, who was the second sponsor of the bill, and you can see him with the original sponsor of the bill, Senator Wilfred Moore, in a photo there, he talked about that philosophy and emphasized the interconnectedness and interdependency of nature. And I think that very well tracks modern scientific understandings, for example, of evolution, and also many people found it greatly inspiring. So as I said, they're the 2 sponsors of the bill who put in a tremendous amount of effort to make this a reality. Senator Murray Sinclair tragically passed away a couple of weeks ago, and we all miss him. And then at the bottom, you can also see the whale sanctuary, that Lori and her colleagues are developing in Nova Scotia, which I was pleased to visit. And you can also see a beluga whale there, and the vast majority of one thing politically is nobody knows what the word cetacean means, but the vast majority of whales and dolphins in captivity in Canada are beluga whales, about 30 or 40 of them. So this brings me to Bill S-15, which is the sequel to the whale bill. It is currently before the Senate, and Bill S-15 would protect captive elephants and great apes. It's sponsored by Senator Marty Klein and Environment Minister Stephen Guilbeault, and it's a government version of some previous iterations called the Jane Goodall Act. Jane Goodall and her organization have been important in bringing this bill forward. And this bill was created by Senator Murray Sinclair, who I referred to. And it was also notably an election promise to Canadians. So we're starting to see animal welfare issues becoming more relevant in the democratic process. The bill would ban new captivity of elephants and great apes unless licensed for best interests, conservation, or scientific research for conservation. This also leaves open that no licenses may be granted, in which case, particularly with elephants, we might see a phase out. The bill would also ban their use in circus-style shows, which have occurred with elephants in Ontario, and it would ban elephant rides. In Senator Klein's view, 2 key points are that the bill can achieve the world's first legislated phase-out of elephant captivity, and that it can prevent the import of chimpanzees to roadside zoos or as exotic pets, which is currently possible. There is some debate over potential conservation value for great apes, and if this bill were to pass, that would become a matter of evidence for independent decision makers with a default ban. So it wouldn't have any, these are not exemptions. These are heads of potential licensing with no guarantee that licenses would be granted. And again, for these species, similarity to humans has been an important aspect. On elephants, the Senate is considering self-awareness, intelligence, emotions, social relationships, range size and complexity, harms and risks, and also winter conditions, as of course all the elephants need to stay inside most of the time in the winter. In terms of harms, it's things like stereotypies, mortality. On great apes, we have similar considerations along with genetic similarity to humans, tool use, and ability to communicate in sign language, all of which Parliament, I think, gives some weight to. So this is a little overview of the scientific evidence on elephants and great apes. So it's extremely exciting to all of us involved that Dr. Jane Goodall supports the bill. She's such a tremendous inspiration to everyone around the world who cares about animals. And notably, 20 elephant experts have also endorsed the Canadian phase-out of elephant captivity. Opponents of the bill are essentially from the captivity industry, especially African Lion Safari, which holds about 19 elephants in Hamilton, Ontario, and CAZA, which is Canada's private zoo accreditor. Though I would note another exciting point is that 4 AZA accredited zoos support the bill. Those are the Toronto, Calgary, Winnipeg, Assiniboine Park, and Granby zoos. And the bill is moving along. The committee voted to support it in June. The Senate is expected to vote on it in December. It would still need to pass the House of Commons, so it's a little bit of a race against time with the timing of the next Canadian federal election now uncertain. Here you can see Senator Klein with Dr. Goodall. That was a very exciting day. And a couple of quotes from Senator Klein talking about the characteristics of these species. Again, you can see that the human-like aspects are significant. And you have a quote there from Senator Pierre Dalphond, who I also work for and who's sponsoring a bill I'll talk about next. And he explicitly drew out the matter of sentience. And sentience, I would say, is a philosophical aspect of this that interests him greatly. One issue that has arisen is whether or not protections would be extended in the future to other wild species. We now know that such protections will not be contained in Bill S-15. There had been some efforts to try to have that happen. However, we now know it won't, but the committee did make recommendations about future protections for other captive wild species, so that's still progress. And the committee specifically recommended that non-native big cats be prioritized. And in Canada, there's estimated to be over 7,000 privately owned lions, tigers, and leopards. Notably, a coalition of the zoos I mentioned and 6 NGOs, including Dr. Goodall's organization, also recommended priority protection for bears, many more species of primates, monkeys, and so forth, and as well dangerous reptiles, such as giant constrictor snakes, crocodilians, and venomous snakes. And that's more on a public safety analysis. But one thing that is interesting philosophically is that the committee recommended factors for future protections for captive wild species. So there was some discussion, we've seen in Europe the focus on sentience, in the litigation in the US, the focus on autonomy. I would say in the Canadian legislation, it's more been a case of, these are factors to consider, and the factors aren't necessarily all to do with sentience, though many of them clearly are. For example, public safety risks would be a factor that is in addition to these, for example, why you couldn't own a cobra. But we also have intelligence, emotions, social needs, ability to behave naturally in captivity, and so forth, and evidence of harms. So now to the horse legislation. So this is Bill C-355. It's currently before the Senate. It's sponsored by Senator Pierre Dalphond, and he's pictured bottom right there, speaking at the Humane Canada Conference earlier this year. The bill would ban the export of draft horses, well, all horses, overseas for slaughter by air. This appears to be a unique Canadian industry. About 2,500 draft horses are shipped to Japan every year live by air to ultimately be consumed raw as sashimi, which is a delicacy, and which is the reason why they're shipped alive. This bill is another election promise of the current government. The bill has already passed the House of Commons, so it's closer to becoming law than the captivity one. It is now in the Senate, although it is facing a possible filibuster from the Conservative Party. And oppositional arguments on this bill tend to revolve around allegations of a slippery slope. The debate is centered around the cruelty of the transport method. So these are very, very long, loud flights. They can, exceed 24 hours in terms of the total time that they're in transit. there's tight confinement with, strange horses. They're not trained for this. Horses are very skittish animals in general, so it's in a very panicked, terrifying situation. There's a letter from veterinarians outlining the scientific reasons for conclusions of cruelty, and also distinguishing the way these horses are transported by air from the way that horses are transported, for reasons of sport and so forth. And here you have a good quote from Senator Delfont on sentience. I thought that Charles Darwin quote is also particularly interesting, but he's referencing Bentham as well, so connecting it to traditions in philosophy and major innovations in science. And just to wrap up, last year, Bill S5 legislated in Canada a transition away from chemical testing on animals. About 90,000 of these animals were used in the most painful form of testing in 2019. That includes guinea pigs, rabbits, mice, and other small mammals, pigs, sheep, beavers, chickens, turkeys, hummingbirds, and many species of marine and freshwater fish. And this measure was also an election commitment of the current government, and it was achieved by Senate amendments from Senators Delfont and Galvez. So the Senate has been a very strong leader on this, and Canada follows the US and the EU in adopting such a policy. Senator Delfont also noted that in 2015, the province of Quebec changed the legal status of pets from things or property to sentient beings by legislation at the provincial level. So that's another exciting development. And Senator Delfont again highlighted the role of sentience in this. So thank you very much from Senator Marty Klein and Senator Pierre Delfont. Appreciate the opportunity to speak today.
Thank you so much, Marty, and thank you to all of the panelists. There's a lot of food for thought here. It's time now to take some questions, and you can put them either in the chat or in the Q&A. And Kathy, I think you said there was one in the chat that...
Yeah, we have a couple in the chat. So one is addressing how these approaches, sentience or rights, consider insects like ants and bees.
Yeah.
So that's the first one. And then the second one is about the social media response to the inaccurate headline leading to government action. And that question is, has that sort of happened in other areas? And given that there seems to be a lot of outcry against the bully ban in the UK. So those are the two questions right now in the chat. So maybe we'll start with everyone's response to the other animal conversation.
Who would like to talk about that? I mean, ants, bees, invertebrates of all kinds are now having their moment. And I hope it is a moment that stays forever because of the science that tells us that these are very sophisticated beings. They share a lot of psychology with us, with other animals, mammals included. So there's a lot of discussion about how this might impact our treatment of insects, for instance. Anyone want to take that on?
Okay, I will.
Okay.
I think within the foreseeable future, there may well be movement on bees. I think the scientific evidence is stacking up, and they are the most likely species to break the insect barrier. I think one of the advantages about sentience is, and I think we have one of the really peculiar things about policy relating to animals is that for more than 100 years, the implications of Darwinian evolution was just ignored. There was a great religious row with the suggestion that humans were animals, but it wasn't really until the 1960s, and actually Ruth Goodall who started to talk about Darwin and saying that, you know, animals are not different in kind, we're the same. And clearly, once you start looking at evolution, it's clear that there are going to be some characteristics which are common between us and them. And the other thing about sentience is that it isn't just looking at, I mean, traditionally it's been looking at, well, what characteristics do humans share with other types of animals? The beauty of looking at it from an evolutionary perspective is that whatever species of animal it is, it's evolved to suit its environment, and therefore you start looking at it from the animal's point of view. And I think, you know, drip wise, Scotland, for example, has just banned the use of glue traps for catching mice. Now, even 5 years ago, I think that simply would have been dismissed as these are vermin, they're pests, it's not an issue. But once you start talking in terms of sentience and having these capacities, is it right to just get them stuck on a mat and left to starve? And no way can that be defended. And I think, as Marty was making the point, that the ethics, the philosophic, the public policy on animals is threefold. It's animal science, it's the ethics, and it's the regulation. And what the science does is change the ethical debate, because it gives us the insight into the capacities of other species, what's important to other species, how they see the world, and the impact of human use and treatment on other species. That changes the ethical debate, and that feeds into the political debate.
And if I could just add one thing, because I clearly agree with everything that you said. I think from a litigation perspective in the United States, the science, you have, it's almost like the chicken and the egg, which is coming first. You have science, you have ethics, and whichever one does come first, we're hoping that the judges can then get persuaded by the science and the ethics, because it's interesting in our litigation, and when we talk about the common law, and that we bring all of our litigation under the common law, because this way we're not cabined by statutes and constitutions and treatises where the judges have to say, okay, what was meant? How are we interpreting that at the time that that particular statute or constitutional provision was enacted? We have to look, it's the role of a common law judge to look at everything that's going on around them. So they have to look at the science, the ethics, the public policy, the general morality. And I think that they're so intertwined. And to me, that's the beauty of the common law and of what we're doing to get judges, because judges are, the law isn't supposed to work ahead of a judge. You know, the judges are supposed to keep pace with what's going on around them. So hopefully when we can bring all of this science before a judge and the public policy and the ethics, the judges will finally say, yeah, we have to keep up with what is evident.
I think the science must come first for two reasons. First of all, it's evidence-based. And secondly, it's non-jurisdictional. If the research demonstrates that hens have a huge need to dust bathe in one continent, that can be applied in every other continent. And the other thing is that politicians and judges and lawyers tend not to be scientists. They particularly with judges, and well, particularly with judges and particularly with politicians, politicians feel comfortable relying on scientific evidence because they think that that will shield them from legal challenge in judicial review.
Yeah. Yeah. Yeah, I mean, well, let's go to the second question because I don't want to miss that one. Kathy, can you articulate that one again?
Yeah, I think it was just basically the person was very interested in hearing, Mike, what you had said about the inaccurate media around the Sentience sort of bill fueling a response, and wondering if that had happened before, and noting that there seems to be a lot of outcry against the bully ban in the UK. And so wondering if there's some connection between those.
Yes, it hasn't happened to the same extent or turned government policy around so quickly. I think they were just so embarrassed that they were being accused of the sort of pre-Benthamite that animals didn't suffer. The XL bully issue is politicians, like judges, like others have said, have to take account of public policy. And what happened with the XL bully ban was that England banned or regulated XL bullies. The Scottish government said it wasn't going to, which meant that very significant numbers of XL bullies were moved to Scotland in anticipation of the ban in England. Then there were some attacks, and clearly politicians were exposed if they did nothing. And so they acted largely on the grounds of public safety, and clearly to protect their own position.
And people might be interested, Marty, in hearing about the social media sort of response to some of the bills you've dealt with.
Yeah, it really played a big role.
Yeah, social media and media in general are critically important. Just to chime in real quickly on the invertebrate issue, in the animal testing debate, there was some discussion of octopuses, I think generated by the impact of the movie My Octopus Teacher. So I think, to me, things like the David Attenborough documentaries and so forth have driven changes in public opinion in a scientific way. And certainly in the case of the horse bill and the whale and dolphin bill, social media is sort of the bread and butter of the political campaigns, move these things forward, particularly where there can be, procedural barriers to overcome. And in the case of the whale bill, that bill barely passed, and it was actually the longest piece of legislation in Canadian history to pass. It took about 3.5 years, and it was almost defeated many times, like 5 to 10 times or something. And in one case, it was going to be defeated, and there was a media story, outlining this, and the public sent in so many emails to the Senate because of a social media campaign that it crashed the Senate server, and the process on the bill ended up being postponed somewhat, and then being saved by Senator Sinclair. So the public sending emails from Twitter and Facebook at the time did save the bill, and it wouldn't be law were it not for that.
Yeah, so very, very interesting. The social media can be very powerful. Do we have time for one or two other questions? Let's see. There is a question here from Docenti01 says, Italy modified its constitution to recognize the duty of the state to protect animals, but the civil code continues to see animals as things, objects. The fear of the legislature is that recognizing animals as subjects of law could not allow a differentiation in the protection anymore. And this is not acceptable because science can help us to put those discriminations in place. So solutions from other countries are essential for the debate as well as the help from other disciplines. So I think, you know, what something, Mike, you said that speaks to this too, is that whatever's true of what's a scientific finding in one country is true in another country. It's not like French lobsters are different than Canadian lobsters. And so it's very, you wish that there was much more communication across different nations on that basis. Anyone have any other points about that?
No, Lori, I think it's so true. And
Oh, yes,
go
go
ahead.
ahead. Okay.
And what I loved seeing in Marty's presentation, when in one of the slides, I'm not sure if it was for the Jane Goodall Act, you had all different scientists. And I love seeing that so many of them are the scientists who support our work, and who the primatologists, of course, you, Lori, the elephant experts, they've submitted affidavits on behalf of our elephant and chimpanzee clients. So it shows how, you know, science does cross these jurisdictional lines, and it's so important.
Yes.
And I would just add, I see beyond science, I see the legal developments in different countries as complementary. So, for example, Senator Sinclair spoke very fondly about the litigation around Happy in the elephant in his speech. Some people would like to see an effort to relocate the whales at Marineland, you know, using any potential legal avenues. So it all informs efforts in different places. But one source of hope with the newer captivity legislation is Jane Goodall's involvement also gives the ideas a much bigger international profile. And because the bill relies on criminal law and on international trade law, virtually any country, I imagine, would have similar laws, where otherwise jurisdiction and forms of law can be quite different. But the ideas of criminal law and international trade might be something that we hope will catch on elsewhere.
I think it's easily forgotten or overlooked how relatively recent the development of animal welfare science as a distinct, discrete discipline is. I mean, you can find the origins of it in the mid 1960s, but it didn't really get a momentum to it until late 80s, early 90s. And now it's being carried out, it's being researched and taught all over the world. The literature has exploded, and our understanding of other species is increasing exponentially. And I think one of the really important things that animal welfare researchers need to do is to, when they do an abstract of a new article reporting their research, they should include a paragraph on what they see as the policy implications. Now, the way academia works is you get your grant, you do your research, you publish your paper, job done, you move on. I don't think it is done. The scientists should become advocates, not just for their research, but for the implications of their research, because they are the best people to explain it.
I'm glad to hear you say that, Mike, because this is what scholar advocacy is all about. It's the Camilla Center's mandate, which is we can no longer, you know, scientists are in a great position to do a lot of good and protect other animals, and they no longer can be on the sidelines. There's no conflict between advocacy and science. And so more scientists, especially young ones, coming.
Yes, there used to be this nonsense that scientists are entirely
should consider the roles of scholar animals.
There used to be this nonsense that scientists should be entirely objective and not have opinions on anything. And actually, Jane Goodall was the person who broke that, because she was sent out as an unscientist. If she had been a trained scientist, she may have looked at those chimps in a very different light.
That's right. That's right. Exactly. There's no problem with being a scholar advocate. Do we have time for other questions? Because they are still coming in.
They are, and we know that people are having to leave to go to work, and we also are intruding on the time of our speakers. So maybe what we should do is end here, but within a call to keep this conversation going, right? So we'll be having more webinars and we'll be having more conversations, but we invite you to reach out to the speakers and to the Camella Center or GW's Animal Law Program to see how we can help advance these conversations and communications and help lawyers and scientists work better together on behalf of the animals.
Yes, and thank you to everyone, and thank you to all panelists. This was a wonderful discussion, and let's just continue, keep going. So thank you all, and be well.